The following is paid programming. Welcome to Something More with Chris Boyd, certified financial planner practitioner and founder of Asset Management Resources, LLC, a registered investment advisor firm. We call it Something More because we like to talk not only about those important dollar and cents issues, but also the quality of life issues that make the money matters matter. Here he is, your fulfillment facilitator, your partner in prosperity, advising clients across the country, your host, J. Christopher Boyd.
Welcome to Something More with Chris Boyd. I'm Chris Boyd, certified financial planner practitioner, and I'm here with Jeff Perry, also of Asset Management Resources, and Scott Birmingham. Brian's going to be with us in another segment, but we have Scott Birmingham, our lead financial planner, joining us. So, Scott, thanks for being here. Jeff, we were going to talk about another timely thing that maybe it's not necessarily a year-end thing, but it's as we kind of wind down the year, you start thinking about checklist type items. What are some of the things we should be planning for, and good items to review from time to time?
Right. This topic isn't just end of year. It has to do with thinking about your estate plan, right? And so you're right on. The first of the year, everybody gets all these goals in mind. Whether it's a health goal, I'm going to join the gym. Probably number one on people's list.
Yep,
I'm gonna eat better. I'm gonna get my whatever their challenge is organized. But I want to stop and talk about your estate plan. First of all, do you have an estate plan? I guess that's the foundational question, right? Do you have an estate plan? And even before that, do you need an estate plan?
Maybe even back up a minute, Jeff. Yeah. What's an estate plan?
Fair enough.
You know what I mean? Like for people, we presumably most people know what we're talking about, but just no harm in just kind of stepping back. What are we talking about?
No. So in real simple, silly terms, where's your stuff going to go when you leave this God's green earth, right? So what happens to your assets when you pass away? And that's the simplest form. Obviously, it's more complicated when you are married, have children, have special circumstances, maybe certain assets, own a small business. But just to get us going, do you have documents in place that will account for your assets when you die? Do you have documents in place for someone else to make a health decision for you if you're not able to make it?
Right. It's not just after you're gone. There's some parts of estate planning that relate to what if I have needs beyond, if I'm not healthy, or if I'm not able to make financial or healthcare decisions on my own. Also, it can be some tax considerations. It's not just it can be creditor concerns. How do you plan to protect you or your heirs from creditor considerations? All of these can be factors that go into an estate planning process
category, right? And so going all the way back,
we do tend to think of it as who gets my stuff,
right? So, well, whatever motivates you to get your estate plan in order, so be it. But the first foundational question is, do I need an estate plan? And the answer is yes. If you're an adult, if you're an adult responsible for your own decisions, you need some form of estate plan. And it may just be starting out with a healthcare proxy where you're designating someone else to make healthcare decisions if you're not able. And it may be a small, simple will of your assets. Maybe you just have, a few dollars saved. Maybe you have a retirement account saved. Maybe you have a car. Maybe you're very minimal in your assets and you're just starting your accumulation young and starting in your profession. But you still need to establish some of these foundational documents. And the more complicated your life gets, the more assets you acquire. When you have children,
the more elaborate your plan might become.
That's correct. So putting this on your to-do list, if you don't have one to do, and I'm going to start out with this caveat right at the beginning. We live in a DIY society, meaning do it yourself, right? And if you can do some things yourself, if you can change your own oil and you want to do it in your vehicle, go for it. If you can put in a new window in your house, sure. But when you're married, when you have children, and when your life gets a little bit more complicated and your assets starting to grow, please don't do your estate plan yourself. There's certainly websites out there that say they have forms and everything for everyone in every state. And that's true. They're probably legal, but that doesn't mean they're going to really meet your goals and meet your concerns and take care of your loved ones or yourself if needed. So
this may be one of those instances where you're
this.
better served to get some help
Right.
for a variety of reasons. And the consequences, Boyd and Boyd, the estate planning law firm that we're in the same office suite, they used to do a seminar, and they said an estate plan is like a parachute. You may only use it once, but you need it to work when you need it, when you use it.
That's right.
To work right,
Right.
So,
that's right. It's absolutely true. And so, we'll talk about some specifics certainly in the next few minutes here, but
I just want to reaffirm what you said, Jeff. I had my estate plan redone, having moved to Tennessee this year, and I think I'm fairly well versed in estate planning basics. But when you sit down with an estate planner and they ask you what ifs with 10 different scenarios, being divorce, special needs kid that you don't think about. What if X happens and she's involved and he's involved and your child's here? And so I think they can pose a lot of scenarios that maybe you didn't think of and throw in the wrenches that you didn't think of. So I think just that conversation alone with an estate planning attorney is very important.
And worth the investment. That it is an investment, but it's important to do it right. And as you said, Jeff, it's not a one and done. This is one of those things that laws change, circumstances evolve, your family dynamics, your wealth, all of these things cause it to be something that kind of like a financial plan. It's not something you just do once and put it on the shelf. It's something that you have to keep reviewing and revising over time.
Yep, you certainly have to revise it when something changes in your life, and you might not think of moving to a different state as a reason to do your estate plan, but that's a good reason because different states typically have nuances in their estate planning laws. Taxes are certainly one of them. You want to do some tax planning in the context of your estate plan. Preparing for long-term care, which we talk about frequently on the show, Scott and Chris. Can be a part of your estate plan if you get divorced or married, or even have a significant relationship with someone maybe that you're not married to.
Yeah, it's a great example. Someone who we work with had a significant other for many years. He passed, and what happens to the house that they've been living in for many years? Do they have access to that or not? And that may not be what is intended, right? You want to make sure you're planning the way you intend things to go, even though none of us expect to die. We all will, so right. Just because you get an estate plan doesn't mean you're doomed to your demise any minute. I know a lot of times people think that way. Don't want to go to the doctor because they'll find something bad. Don't want to go to the estate plan, to the attorney to do the estate plan because maybe it'll push the issue, not necessarily the way it works.
But you do bring up something that reminds me of a very good point, and that is a lot of people are hesitant or reluctant to do an estate plan because they actually have to face their own mortality, and that's a fear for some people, and they just push it down the road, kick the can down the road because they just don't want to deal with those questions that they're going to be asked. But if you really think about it, an estate plan, if you're thinking about it for yourself, is not for you. It's not, you're gone, right? And so it's a selfless act for the people that you love and the people that you want to account for and take care of after you're gone. So this isn't for your own benefit, right? This is for the benefit of the people who are here. And you can either create a system that is very comprehensive and very logical and detailed so that there's really no questions, there's no arguments, there's no strife in the family. And you can set up generational situations. You can set up trusts to take care of certain individuals over a long period of time. There's endless things that you can do, and you're doing it for your family. And so, if you've hesitated doing an estate plan or you haven't looked at your estate plan and it's just not something that's really something you want to do for whatever reason, I think you have to look at it like that. This is a gift you're giving to your family.
That's a really good point. And it is something that can be hugely impactful, and the approach you take can affect the amount of time and energy that your family has to deal with in the in the process, and there are a couple of key decisions along the way that people decide what's the approach they're going to take. Are they going to have a will-based approach to this? Or are they going to use a trust? If they use a trust, again, assets can play a role in deciding some of these things.
Right.
If they use a trust, are they going to use a plan that's geared to deal with Medicaid planning and an irrevocable trust approach where they may try to divest themselves of wealth in an effort to retain it intergenerationally, but maybe limit their own access to their own resources? Or are they trying to use a revocable trust, which doesn't protect it from spend down, but gives you more control and use of your funds? These are some of the initial big decisions, and I think one of the things that's challenging when you deal with an estate plan, Jeff and Scott, is making those decisions about who. If you have kids, it's really important to have some plans for if they need a custodian. Who's going to do that? Who's going to be that? And of course, no one is you. No one is as good as you would have them be.
Right.
But who's your best option today? And it may be different if you move 5 years down the line and you say, you know what, maybe it's a different person at this circumstance, or and then who's going to handle the financials? Who's going to handle the healthcare decisions? Scott,
it's not always the same person. Yeah.
No,
Right.
and it may be different people. And you've just been through this, you said. So, you can probably attest to this. It's really challenging to think about who do I want to be that person for different scenarios.
It is, and there's just a host of different decisions and factors played in. But I had a health scare in the summer, and I'd finished my estate plan, redoing my estate plan, probably 2 months before. But I actually hadn't given a copy to my fiance, so I'm in the hospital emailing a copy of everything to her to make sure she had it.
Oh my gosh, yeah. So good point. You have to let people know and how to find who's going to be my healthcare proxy. Here's where the document is. They have to sign off that they're accepting that power, perhaps.
Right.
That is one of the most common mistakes. That we can talk about some of the common mistakes too. But that is one of the most common mistakes is, people do go through the process. They get their documents in order, or they make their changes. They do their updates, whatever, and they don't communicate those decisions and those documents with the people who are going to need them. I was a practicing attorney for a while. Listeners may know. And I would have people who did the entire estate plan and ultimately pass away, and their executor, who's the person responsible for taking care of their will afterwards, or a power of attorney or a healthcare proxy, don't even know that they have been selected by their loved one to fill this specific role. And
well, a lot of families try to keep things close to the vest, right?
Especially when there's more than one child.
They don't necessarily want the kids to know what they're worth, how much they have. They don't. They may have rationale as to why they've selected one person or another, but they don't always disclose that. And I think sometimes that can create some tensions in families if you don't disclose the rationale. And it can be, when someone passes away, there's a lot of raw emotions that bubble up. You always were mom's favorite or whatever, right? And so, they have these issues where if it's not been kind of clearly delineated, well, we decided, and sometimes it's just, well, you're the oldest, that may not be the best plan just because someone's birth order, but it can be, well, we thought they would have the time. It could be, oh, we thought their skill set would lend themselves to being attuned to the financial, whatever. It can be just, this is why we decided it. Sometimes can be a helpful explanation to the heirs in understanding it's not that we didn't love you, that kind of thing.
Right. There was and that goes to some advice that I think most attorneys give to their clients is that after the estate plan is created and executed, not only do you give a copy to the executor or power of attorney or whoever is you're asking to do, and you've got their permission, of course, but most attorneys recommend a family meeting, or at least offer a family meeting where, in the case of the parents, we'll say, and the children, if the heirs, that you all get into the same room together with the attorney. Many attorneys offer these meetings, and go over it. And it's a very uncomfortable thing to think about.
I'm always nervous about a family meeting that it's going to just blow up, that it's going to end in a feud, but you're right. I think part of the importance of it is it's an opportunity for a parent to say, this is what I've decided. It's, it's not for discussion. It's like, this is what I've decided. And I wanted you to know, and I wanted you to know the thinking behind it to some extent.
It can also dissuade people from making legal challenges,
contests and stuff.
Yeah.
That's important to talk about. Just, a will by its nature does invite a contest. It is a directive to the probate court that says, hey, after I'm gone, here's what I think I want to have happen. And when there is a will, the probate court has to say, well, anybody else have a different will? You got another one? Is there a more recent one?
And a public process.
It's a public process, and it invites the potential for contest, which a trust has less of that. It's a more private process, and you can even say, and if you challenge this, you're out. So you can have terms in there that can be a little more delineated. You mentioned some of the fails. What are some of the things that the mistakes people make? What are some of the things we should be mindful of?
Sure. Another common mistake is when people are dividing up their assets is they choose a numeric number, a money number. So let's say, the gentleman in this case is preparing his estate plan, and he's got 3 kids, and he currently has $1 million. And his goal is to divide it up equally and give some to charity. So he starts saying, I'm going to give, $200,000 to charity and blah, blah, blah. And so he has these figures in his estate planning documents. We'll say a will, just for sake of simplicity.
Yeah.
And then numbers change over time. They go up or they go down.
Yeah.
I'm familiar with one situation where the decedent, the person making the will, decided to give a certain amount to charity as a top line, and the rest to be divided by the children.
Percentage to everybody else.
Right, because at the time he made the will, he was much wealthier than he was. So at the time of his passing, when he gave the specific amount to a charity, which was a university, there was virtually nothing left for the children. And I don't know what his intent was, but at the time of the will, I was not his attorney at that time, but in essence, what he did is give most of his
estate to
the university and very little to his children. And I don't think, from what I do know, that was actually his intent at the time.
It's a great point. That's an easy thing to adjust.
By using percentages, right?
Either percentages or X percent up, not to exceed. That kind of thing. Is be a way to do that.
Yeah.
So what are some other common
so I want to say misconception and then turn it into a common mistake that people make. So most people have modest means, and that's defined very broadly, but most people when they're going in and they haven't had a complex estate plan perhaps contemplated or ever in their families, they are thinking that they're going to need a will and some other documents, but they think a trust is for the wealthy people, right? Yeah. I don't need a trust. I'm just giving my money to my children, or whatever, something simple.
Yeah.
But then they're shown the benefits of a trust, even if it's a revocable trust, and they're just doing it for simplicity, or maybe setting up time frames of giving, or whatever the reason they decide to do a trust, they do it. And then here comes the mistake. They don't put their assets into the trust. They leave the lawyer's office with all these beautiful documents all executed. They talk to their trustee, in this case, their executor, and their healthcare proxies and the power of attorney. They tell them all these things, that here's the plan, and they don't actually take the time to, if it's property, to deed the property into the trust, or if it's financial assets, maybe a brokerage account, or maybe whatever the asset might be, they don't retitle them in the name of the trust. So when they pass away, their will is actually the document that's taking care of these items that are not in the trust, because if it's not in the trust, it's not subject to the trust terms. Now, you can deal with that in a will, certainly, if it's done correctly by pouring over the assets from the will into the trust. But many times people don't end up using the trust the way it was intended at the time of the
that's
creation
so
of
true.
it.
People walk out the door, they put the book on the shelf, and don't really fund the trust the way it's thought to be intended to be utilized.
And they don't, I'm taking a shot at some of my fellow attorneys out there, but the attorney doesn't do a good job at communicating that they have to do it. They think they've done it. They walk away and they have a trust, and they think they have a trust. They have a document, they have a trust, but there's nothing in it.
And how to do it, specifically how to accomplish
That's right.
it.
That's very confusing to people. You're right.
Good point, Scott.
Just maybe just touch on that, Scott. An example, at least as in our world, just because you say an account is in the trust doesn't necessarily get it into the trust.
I've seen it all the time, revocable trusts, and people want to use that as a beneficiary, for example, for their IRA, because it gets more specific on who's getting what in certain circumstances, whether it's as a primary beneficiary or contingent. And they just haven't applied it to the proper places. So it's simple. You go to your whatever brokerage platform you use. You can do that online yourself, or you make a phone call. You usually submit the document and rename the beneficiary. Very simple. But people don't do that, on a regular basis. They don't know that.
Well, that can be a problem sometimes if you leave something to a non-person beneficiary. It may limit you. Instead of having a 10-year clock, you may have a 5-year clock. So there are some specific rules, and if the trust is established the right way, who permit how that would be handled. There are some trusts that are designed for this kind of thing, and there are some that are not. Additionally, I thought you were just going to say like a joint account. You want to move it into the trust. It's not a big deal, but you have to change the title. And it's not terribly difficult to do, but just
takes no time.
Just has to be processed as a form to do.
I think of the beneficiaries because I just think it's something that slips. If you're using the trust as beneficiary, you open another IRA somewhere, another Roth, something through work, it just slips your mind. You set it up somewhere. You haven't done it elsewhere.
Yep. And one final thing. I know we're short on time, but the other thing that I see people being not intentional enough about is those tangible assets they have. They may have specific things that they would prefer one member of the family gets, or not just leaving some broad categories saying, a third of my personal property to these 3 individuals, but either being specific about it or setting up a process of how that a third. I've seen lotteries done where there's one child gets to pick something, then the next child. There's lots of ways. Don't have time to go into them all, but to create a process or be specific about who gets what, because there's much controversy and stuff. You think about estates with millions of dollars, it's all nice and clean, and then when they get into the house and who wants what, the siblings are completely
or one sibling has a key to the house and the others don't, and or whatever. You know what I mean? You can see how things can go unexpectedly awry.
Who gets the gold bullions and who gets the 1970s Pacer?
Yeah,
right.
Right. Well said. All right. Well, anyway, interesting topic, Jeff. Thanks for.
Or the executor just goes in and sells everything. Right.
Yeah. Not necessarily what someone might want. Yeah. Good point. So, all right. Well, in any case, good reminder, some basic things to think about. If you need help in thinking about, your planning, whether it's financial planning, portfolio management, or a little bit of insight as to how this, estate planning can affect your other plans, certainly reach out to us. We're happy to talk to you. Until next time, keep striving for something more.
Thank you for listening to Something More with Chris Boyd. Call us for help, whether it's financial planning, portfolio management, insurance concerns, or those quality of life issues that make the money matters matter. Whatever's on your mind, visit us at amrfinancial.com or call us toll free at 866-771-8901 or send us your questions to radio@amrfinancial.com.
You're listening to Something More with Chris Boyd, Financial Talk Show.
Asset Management Resources
Services, LLC, and J. Christopher Boyd, CFP, provide investment advice on an individual basis to clients only. Proper advice depends on a complete analysis of all facts and circumstances. The information given on this program is in the nature of general financial comments and cannot be relied upon as pertaining to your specific situation. AMR, LLC cannot guarantee that using the information from this show will generate profits or ensure freedom from loss. Listeners should consult their own financial advisors or conduct their own due diligence before making any financial decisions.